Hey, not live, pre-recorded from Denville, New Jersey, is the Second, Fourth, and Eighth Amendments. All right, guys, this is 3.5 and 3.6 if you're following along with the AP government unit breakdown. These are topics that we could talk about for hours and days, right? But these are going to be brief overviews. I want to keep in mention that these are also heavily debated, right? I don't want you to think that any photo or image I may have used is showing some sort of bias. I'm just trying to throw some images in here. And we can talk about the different sides of a lot of these issues in class or later on. So what do the Second, Fourth, and Eighth Amendments have in common? A lot of this is sort of legal stuff, things you might learn about if you take criminal justice, for example. Second Amendment. I told you this was hotly debated stuff. Look at this. All right. A well-regulated militia being necessary for the security of a free state. The right of the people to keep and bear arms shall not be infringed. All right. So there's a lot of questions here that people have asked over time. So does the Second Amendment, is it dealing with militia or is it dealing with guns? Okay. Militia. I'm sorry, or individuals, not guns. Yes, we know it deals with guns. Or so is it militia or the people or individuals? And regulated militia. So does that mean arms can be regulated? Well, the answer is sort of all of the above as it has evolved over time. So in the first place, why are they even talking about militias? Now, if you've taken some history, when you get to APUSH, you'll learn about the militias in our revolution, right? Where it was literally people in their homes who had their own weapons. Of course, they would train sometimes. They weren't just like, had no clue here, but they weren't like they were farmers or, they had jobs and they would respond. The early republic feared a standing army. Like, we have an army, a navy, air force, space force, right? They're always there, right? They feared that at the time, right? The world was sort of different then, right? They're like, well, who are we going to send near the Ukrainian border, right? They didn't worry about that back then, okay? So the people instead had their own weapons. And then you would have a peacetime army, maybe for national defense, and you could then regulate these state militias for everything else. So, when I was first in getting my master's in American history, I was really torn with this idea, like, why would they not want, a standing army? Like, they just fought Britain. Wouldn't they want that? But remember how a lot of these amendments are to sort of undo the things that the crown did, that the tyranny of England did. And they saw the standing army as one of the king's abuses, especially when they were just like there living in their towns in Boston, right? So they wanted to not have that. So you see a quote from Madison at the Constitutional Convention here, right? Will not long be safe companions to liberty. So if we want to keep our liberty, we don't want this standing army that would be an extension, a tool of the crown. And our buddy Adams also said, if you have a standing army, you need to keep a good eye on that, right? So that's why militias were the better option at the time. And there's two main views when we look at this. It's that there's individual rights and there's collective rights, so rights of the people and rights of individuals. So the idea that, yes, individuals do have rights to firearms was more confirmed, if you want, more recently in our history, after the 21st century. And we have a case in 2008, DC versus Heller. And that sort of said that it's not just for militias. Individuals can have firearms for self-defense, for hunting, for shooting those clay pigeons in the sky, right? And also the firearms that they could use could be the ones that were most in common use at the time, right? We're not all going to go around using these muskets, right? But it also and I find this sort of funny, prohibited ones that were dangerous. Well, of course, firearms are dangerous. So how do you can't prohibit dangerous firearms, but ones that were exceedingly dangerous or unusual weapons. Imagine what those could be. Okay, so even though individuals had this right, it was not unlimited. Their firearms would have to be licensed. They couldn't bring them to certain locations, right? You can't bring your firearm into school. Some schools you could back in the day. Ask me about that. Populations like felons, right? But they did have a right to individual ownership, due process if they felt that their gun ownership rights were being infringed. There are some exceptions where law enforcement or military personnel at times could have them, maybe at times in places where other individuals would not be allowed to. I can tell you more stories about that as well. So yeah, people can't have nuclear bombs. It's not legal. All right. So now there were regulations on these rights. And these regulations came through the powers of Congress because Congress has enumerated powers. So, what can Congress do? Congress can tax things. So, Congress can tax the sale of firearms. We also have commerce laws being sold, especially between state borders. And this comes of the Gun Control Act of 1968. You see LBJ here signing it. And this act did a few things. It prevented mail order sales, like unless it was like to individuals. Like you imagine, like, oh, my gun came in the mail today, like that kind of thing. Prevented felons from buying guns, certain drug users, ones deemed mentally incompetent, things like that. And this was the first major gun control law in over 30 years. But think of some historical perspective. Why did this come about in 1968? Well, Lee Harvey Oswald, you may remember, killed, or did he, JFK, and he bought his weapon through the mail from an ad in an NRA magazine at the time. Crime was going up. There's a lot of protests, some related to civil rights, some not. In the late 1960s, you also have Martin Luther King, his assassination that April, and then RFK's assassination as well that June. You also have, now a lot of that, I shouldn't say a lot, some of that act has been modified. We can talk about that as well. Also, gun-free school zones, which were also modified. We'll talk about that when we talk about US v. Lopez, which is actually more about the Commerce Clause than the Second Amendment debate. Congress also has spending power, so they could incentivize states for implementing certain regulations. They can give money to states to use the FBI for national background checks and all sorts of things like that. So what is not unlimited? Oh, and this Time Magazine cover was from the when that act was passed in 1968. And they thought, it was better than nothing at the time. They wanted some more stuff to deal with it, national registries and things like that. Anyway, you can't own a weapon anonymously. They have serial numbers, registration, and all those sorts of things. So the all carry options. New Jersey is much different than many states when it comes to carrying things, firearms. In some states, you can have concealed carry. In many states, actually, but it's different from state to state. All types, you can't just have any type of weapon. There's the movement for some and some semiotic weapons. You can't have armor-piercing weapons, for example. All places, I mentioned, like schools. You can't bring your weapon to Six Flags, or all people. And that usually, like I said, deals with felons, some people deemed mentally incompetent, things like that. If you have been paying attention to the murder of the two New York City police officers recently, the second one's funeral was in the city today. That one of that concern is that weapon was not like registered to the proper owner. They tracked it back to like Baltimore. So how do you, even if you have registered, like how do you monitor all that? But if you abuse that right, you can be penalized legally for it, obviously. All right, so now let's talk about 3.6, balancing individual freedom with public order and safety. So democracy, right? When you have all these liberties, that's great, but if they're not checked, that can cause all sorts of problems. So besides sort of hoping to have moral avenues to provide a compass to people, you also have some regulations. So the Fourth Amendment, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons of things to be seized. So nowhere in the Constitution or in our amendments does it specifically say the right to privacy, but it's implied in a few places, and this is one of them. To be secure in their persons is seen as a right to privacy. Also, who deems what is unreasonable and who deems what is probable cause? Well, they say it's by reasonable people determine what that would be. So if there's a warrant, there's certain things that have to happen before and certain things that can or cannot happen after. I'm hoping to get maybe a detective in to talk to us about this. But so you need to have probable cause. You can't just be like, I'm going to go search this person's house, right? And with probable cause, it has to be that you have good faith and reliable information, a specific place and time, a neutral magistrate. In other words, a judge can't like have a thing against this person, right? They have to be fair. Okay, then afterwards, outside items that they may have acquired are not admissible if they weren't obtained through the warrant properly. And that's known as an exclusionary law, not war, but also the fruit of the forbidden tree. So, like, you have to, if you have suspicion for another thing, you then need another warrant. You can't just sort of search in a different way for something else. There are exceptions to this, all right? If you're searching a place and something is out in plain view, it's sitting right there on the table, it's not hidden under a mattress, okay? That can be used. If the person gives you consent, hey, can I look in your closet? Sure. Okay, well, you said sure, so now anything in there is admissible also. If there's an incident during the arrest, you're fighting your arrest, so as you're struggling, drugs come out of your pocket. Well, they didn't have the warrant to search you, but now that's fair game. Exigent circumstances are like if something is in danger and you find something. A child is in danger, so you get them out of a room. Something that you have a loyalty to try to help in that dangerous circumstance shows evidence. Also, there's stuff for auto exception. Automobile is not considered the same when it comes to privacy because, like, you register your car through the government and all those sorts of things. So the probable cause, there's some things, gray areas with that. There's also technology-based exceptions. You should have learned freshman year about the Patriot Act. You can stop and go search that up a little bit if you want to remind yourself. That has been modified through the government over time, but that gave law enforcement access to electronic surveillance. And that happens, right? That does not mean, which some people think, like, oh, the government's just looking through all your emails. No, there still needs to be just cause and have things in good faith. Just because they can does not mean that they do. And if they do, then that could be illegal. There's also the idea of implied consent. That could be an example with you're driving and you're giving implied consent if you're unconscious for them to test your blood because they suspect a DUI. Right? I guess you can't be driving if you're unconscious, but I would suppose an accident, right? There's also biosurveillance. If they suspect you're a victim and now they can do DNA, this is something that wasn't around decades ago. Well, they can probably find some of your DNA in the trash because you probably touched those things, right? And if you discard your trash, you're just giving it away. so they can find your DNA. So that's Bush below signing the Patriot Act. Remember, that was a result from 9/11. Also, something that's been in the news now, and it's been going to court. What about if you give your DNA to Ancestry.com or that history or the 23andMe? That can the government tell that company, hey, we need that DNA to test them for a thing? And they were, but now they think maybe not so fast. They keep in mind, it might even just be you. Like, your DNA might be able to incriminate a cousin or a grandchild or some sort of relative. So you can tell all your relatives who donated to those things that let's hope they didn't put any potential criminals. Let's hope there's not at risk. I give my brother a hard time for that. I said, great, now my great-great-grandchildren can be incriminated. But you know your family tree. All right. Now, how does this balance liberty versus social order? Right? So what I want you to think of is that for every right we've talked about since we started this unit, you have a liberty, but there's also some regulations to that liberty. None of these rights have no boundaries. There's limits to all of these rights, and we have to remember that. Because without limits to these rights, there's no order. Okay? You have just people yelling fire all over the place. So I'm going to just give you a few examples here. Okay? So we know we have a freedom of speech, but you can't commit slander because then you can get in trouble for that. Okay? We know you have free exercise with religion, but there's also the Establishment Clause to say, well, they can't mandate as well. There's a free press, but you also can be in trouble for libel if you abuse that. And there's more, like if you have gun rights, but there's also gun regulations. Okay? You can't have unreasonable search and seizure, but they can at certain times, use these warrants for public safety. All right. So try to see how the courts are continually trying to balance this, how the regulations are continuously evolving and reinterpreted over time. So while we think about that, let's look at the Eighth Amendment. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. Everyone loves that phrase, cruel and unusual, right? So excessive, right? Who determines what excessive is? What is cruel? What is unusual? And it's usually all what reasonable people determine, sort of like a social contract. Okay? Let's go back. Remember, life, liberty, and the pursuit of happiness was influenced by Locke's life, liberty, and the pursuit of property. So life and liberty, cruel and unusual, but no excessive fines because your money's your property. You see this idea? There's no word property, but you see this throughout these amendments. So once again, what's looked at is what is reasonable and what's proportional. The bail, the punishment, the consequences should be looked at the seriousness of the crime, right? Someone used for their meme stealing a hat. Well, stealing a hat is not the same as stealing a car. And that's not the same as killing someone, right? And for example, also, are you a flight risk? Do they think you could leave the town, the state, the country, right? Are you a traitor? Right? All these things are kept in mind. Now, the death penalty, another thing like the gun debate that we can talk about forever, and there's lots of different opinions on this. So let's look at this case, Furman versus Georgia. This is not one of your mandatory cases, but it's important to understand this. And this was determined that cruel and unusual had to, they looked at what is cruel and unusual. We have to think what is arbitrary and what is capricious. Keep in mind, Furman was an African-American man, and this is when you really start to see more of the research of the injustice in the justice system, right? Why are there more African-Americans on death row? And cases that came about, they said you can't look at the statistics in determining the decision, but you can look at that to determine, is this being carried out justly? And Furman was committing a robbery. And the homeowner woke up. he got scared. He turned to run away. He tripped. When he tripped, he fell. The gun went off, killed the homeowner. So he was trying to rob, but he didn't end up robbing. But he accidentally killed someone. His goal was not to kill someone. It was a complete accident. So the defense was, this is bad, but this is not the same thing as someone who goes into someone's home and shoots someone. He did not mean to kill anyone. And you don't kill people for burglarizing, and you don't kill people for making accidents, right? So the majority opinion was that the imposition of the death penalty in these cases constituted cruel and unusual punishment, and it violated the Constitution. And this created a de facto moratorium on the death penalty in the United States. Let's pause, and make sure that if you're going to use the death penalty, right, let's look at this arbitrary and capricious idea. And it was not revised until a few years later in 1976. And that was under the case of Gregg in Georgia. And some things came about this. They said, well, there has to be two trials, first of all. So you have a trial to determine your guilt or not, and then another one for your sentencing. So what did Gregg versus Georgia? That one actually covered, like many of these cases do, 5 different states that were trying to still use the death penalty. Southern states, take from that which you will: Georgia, Texas, Florida, North Carolina, and Louisiana. So they said that there needs to be evolving standards of decency that determine what is cruel and unusual punishment. So, you can't torture someone to death. Maybe the electric chair isn't cool, right? Lethal injection, that seems to be evolving into decency. That's been in the news lately because many of the drugs for lethal injection came from France. European countries, Western European countries don't use a death penalty, so they would not sell US the drugs anymore. So then these US, we needed to find new drugs, and it was causing problems. And some of those deaths were in fact not working, not like they weren't dying right away. They were being painful. So once again, was this now considered cruel or unusual? So let me just tell you, this was a 7-2 decision. All right. So this brought the death penalty back, but certain standards now had to be met. All right. And they had to show that each state, in order to bring back the state's death penalty, had to have these. Keep in mind, there's no New Jersey death penalty, right? But you can still be from New Jersey and get the death penalty under a federal court. Doesn't happen too much. There was a long time when there were no federal executions. You may remember the last days of Trump. A few were carried out, or I don't remember the exact number. But I want to tell you something that you're not going to get in the AP Gov videos. What happened to Gregg versus Georgia? He sued when he was on the death row, saying, the death penalty is unconstitutional. We saw that in Furman versus Georgia. And the case was like, well, no, it is now, because it's under these right ideas. Was it the night before his execution? He escapes. Him and a few others escape. He escaped death row. Crazy. Like, security light enough in death row when you just escape? A few hours later, they're in a biker bar. He gets killed in a bar fight. They find his body in a river. And on that note, I'll leave you guys. All right? See you soon.